Hey everyone, this is Andy Ramay here again at the Ramay Law Firm, and I wanted to do a follow-up video after my last video where I talked about how a will could be one of the worst ways to transfer property upon your death. And I didn't want y'all to think that I was somehow anti-will or didn't think you should have a will, because frankly, I think everybody should have a will. My point in my video was just that a will is only one tool or one way to transfer property upon your death, not the only tool, not the only way, and sometimes it may not be the best way. It could be the worst way because there are other ways. And so, to follow up with that video, because I don't want you to think that I'm anti-will. Again, I think everybody should have a will. You should always have a will, even in the situations that I described in my first video, where we have the assets set up to go in the non-probate avenue. You still should have a will just in case. I mean, sometimes an asset shows up that we didn't know about, or that maybe it was a new asset that had not been placed in the new plan, and so you still need a will. So I wanted to follow up video here to give you some benefits of a will and why I think you should have a will. Will is a great tool, and I think everybody should have a will. So one of the first benefits of having a will, and this is if you or your spouse, whoever it is, if you have minor children. And the reason that is so important to have a will, particularly if you have minor children, is because one of the things that a will allows you to do is to appoint or nominate a person to be the guardian or the conservator or trustee over your children in the event you pass away, and at the time that maybe the mother or the father of the child has also passed away. So the event that both parents are died or have died, a will allows you to appoint somebody and say, listen, if I die and the mother or the father of the children is dead too, I want this person to be the guardian of my children. I want this person to be the conservator of my children's money, maybe the trustee if there's a trust in the will. And so it allows you to appoint those people rather than, after you die, your family having a big fight and figuring that out. They know your wishes. So, it always kind of surprises me when I meet people that come in and they've got children and they're minor children, but it's something we never think about. I mean, I understand that. A will's not something, death, we don't like to think about that. But I just want to encourage you that if you have minor children, really, really, really need to get a will, if nothing else, to be able to think about that. And I know even for my wife and I, it was a very tough decision to make that. But again, you would rather do that ahead of time and be prepared and make sure you've made that decision, so that if that event happens, and hopefully it never does, but if it does, then the will suggests who you would prefer. And so a future judge or whoever may be making that decision will have insight from you into who you would have chosen. The second benefit, and again, this isn't going to be an exhaustive list. I mean, I could go on for days about what the benefits of a will are, but this is just the second one. The second one is you get to pick your executor. If you die without a will and you have assets that need to be transferred to your family, you get to pick your executor with a will. So maybe you have 4 or 5 children, or maybe you don't have any children, but you got brothers and sisters, or whoever would be the person administering your estate in the event you die. This would allow you to pick somebody to be your executor. And again, the executor doesn't get to just do whatever they want to with your estate upon your death. An executor has to follow the law for the state of Georgia, and they also have to follow your wishes in your will. But again, you want it to be somebody you trust, and somebody that you know is going to do what your will says and going to do what the law says. So again, you get to pick your executor, and that's a good thing. If you die without a will, listen, I've seen it. You die without a will, and your kids are fighting over who's going to be the executor, and then it's just a mess. So why not have a will, and why not go ahead and pick who it is you think you want, or who you want to administer your estate? So that's great. Why not have a will? I would say one of the third things is the benefit of having a will is you pick beneficiaries. I'll just do that. So if you die without a will, the laws of intestacy. So the legislators, I should say, have chosen in the code book, in the statutes, what happens to somebody's property when they die. And there's the laws that say if you die without a will, this is what's going to happen. Well, that might not necessarily always be the way you want your property to be distributed. So again, when you have a will, you get to say, this is what I want happen to my property. Okay? You get to choose that and not rely on some legislator and whatever the legislators decided years ago should happen to your property upon your death. And that's a great benefit. And another big one I would come up is waiving bonds, inventories. I'm kind of writing fast, but it's okay. And returns. If you die without a will, one of the things that you have to do to become the administrator, just a little nugget here, if you die without a will, you're appointed the administrator. If you die with a will, then you're generally an executor. But if there's no will, unless all the heirs consent, the judge is going to require you to get a bond for any personal property. You're going to have to do an initial inventory. You're going to have to do yearly returns. And of course, that costs money because generally you're having to get a lawyer to help, and it's just aggravating. So if you do a will, though, you can waive, and almost all the time, you waive bond, you waive inventory, you waive returns, obviously because you've picked an executor that you trust, and you don't think that executor needs to get a bond, you don't need to have an inventory, you don't need to do returns and all that. So that's a huge benefit to having a will, is being able to waive bonds, inventories, and returns. So that's great. And I'd say maybe lastly, is just control in general. You can put things in a will like a trust. So if you want the property to go to your children, you can put provisions in there about when they get the money. You may not necessarily want an 18-year-old getting $100,000 because they're going to go buy a brand new Corvette or something, which is not necessarily what an 18-year-old needs. But on a will, you can set up trust. And I guess that's if you have minor children, but you can set up trust and say, well, I want the trustee, who you get to choose, to hold this property until my children are a certain age, and then they get it. I mean, you can be as creative as you want to in that regard. So, a will does give you a lot of control, not only picking your beneficiaries, but controlling the property even after your death and kind of getting to say who gets what, when, and where. So that's a great benefit of a will. So, I hope you enjoyed this video. Again, I've got a lot of information about wills. We've been doing this for a long time. And, I hope that that my position is, again, that I think you should all have a will. There's great benefits for a will. But again, a will's not the only tool for estate planning. There are many other avenues, and I addressed that in my first video. So again, Andy Ramay here at the Ramay Law Firm. We'd be happy to talk with you about any kind of probate issues you have or estate planning. 912-375-4500. Just give us a call. Thank y'all.